In theory, one good example could be Waka Waka making a treaty with the Queensland Government, the signatures on the treaty, the representatives who can speak for the Waka Waka and the Queensland Government, the Premier or the Minister is signing the treaty. That ultimately would be the parties to the treaty.
In response to the treaty issue, treaty is a good idea provided it can be done in the right way. First of all, you don't do a treaty with somebody's agent. You wouldn't do a treaty with the state government. There are in this system, they're only an agent of the federal government, which is an agent of the Crown. You either do a treaty with the Crown that has enforceable provisions, a treaty, that's first. Secondly, you don't just do a treaty with them because they're completely untrustworthy and they've had hundreds of years of unequal treaties.
You so beautifully described is the legal doctrine called non est factum.
Yep.
That means they get you to sign a document, you think it's one thing, but it's actually another.
Yep.
And it unravels the whole document. And it's an act of fraud. If you spread it in amongst the folks that these things are non est factum and say that to the official, once they realise that you think it's non est factum, they can't force you to sign it under any circumstances. Non est, est, factum, F-A-C-T-U-M. Particularly applicable when the person signing it is not educated or who speaks primarily another language. That's what the law tends to show. Unravel. Section 116's major power is a little word in there that's, I think it's in other measures. That means they have administrative control. And once they've got administrative control, the officials have complete power and they don't have to act in accordance with the law. And if they hurt you or commit a tort or any other wrong against you, you can't sue them.
Yeah. Thank you very much.
Thank you.
I think that's the strategy behind the old constitutional recognition process, is to blindfold us into thinking that we're moving in the right direction, but in effect we're actually signing away our sovereign rights.
What worries me about recognition is that as soon as you become subject to their legal system, they'll decide you're committing criminal offences and just lock up everyone in one big sway. And another thing you need to know, that at international law, this little phrase, deaths in custody, is code for government death squads. It's known all around the world in international law that when they put death squads together, there aren't bunches of police running around killing people. They just put you into jail for parking ticket offences and step on your neck. And everyone says, oh, well, the person was a jailbird. And there's just no public response. So it's known in international law, deaths in custody means government death squads. And you have to reframe this, tell them you know. Because they work on deluding people. I've just written a paper on the songlines. And in that paper I say that the reason why they're bulldozing all over the songlines is because they got the missionaries to make everyone think they have a religion, whereas in actual fact they have a functioning legal system. And they say, oh yeah, just a religion, isn't it lovely? It's so spiritual and artistic. It's a legal system. We were in the ACT Supreme Court recently and said to Ref Shorty, the Chief Justice, you've got to apply using the conflict of laws rules, the Aboriginal law. If you're not doing that, you're breaching the jurisdiction of the court. And he went and said nothing.